but we will get started. I'll share my screen with Donna's PowerPoint here. And yeah, if you just want to get started off with an introduction, Donna, we're expecting like 5 more people. And let me just pull up the slides here again. All right, sharing them here in 1 sec. Awesome, can you see that?
I can, it's great.
All right, I'll mute myself and turn my video off, and you just let me know when to flip through the slides, and I'll just let the participants in. We're expecting a few more, but yeah, we'll get going here.
Okay, thanks very much. So we're going to talk today about intellectual property law agreements. So just we're going to talk very generally about, I'd say a little less than, probably around a half a dozen types of agreements. There are others. These are the basic ones that I thought would be important to talk to you about today. So who am I? I'm Donna McEwen. I'm a lawyer at McInnes Cooper. We're a regional law firm. We have offices in each of the Atlantic provinces. I specialize in intellectual property. I've been a lawyer for about 30 years, so that'll date me. Everybody will know about how old I am. And so I'm also a registered trademark agent, and I have been for about the same amount of time that I've been a lawyer. So we'll get into it. So we'll go to the first slide, or the next slide. Thank you, Rachel. So I'm just going to talk about the types of IP, because people will often come to you and not being familiar with the terminology. They'll ask you if you can get them a copyright registration when in fact they're looking for a trademark registration. So just as a little refresher, and quite quickly, I'm going to talk about the main types of intellectual property. So we've got trademarks, which basically, no, we got to go back once, thanks. So we've got trademarks. Trademarks protect your brand. So that's brands like McDonald's, Coca-Cola, Kodak, Startup Zone. Copyright protects creative works, you know, songs, poems, books, paintings, and computer programs. The Parliament decided back in the day, when they needed to find a type of intellectual property to protect computer programs, that they would add them to the Copyright Act. Not all computer program companies are happy about that, but regardless, it is protected by copyright. Patents protect inventions. Industrial designs are not common, but they are certainly important. They're basically design features that are added to something that you manufacture, or manufactured products. They're meant to be pretty only. Aesthetics only is the only thing that's protected, no function. The function of any manufactured article is protected by patents as an invention, but industrial designs can be designs added to one of these manufactured goods. It can be their shape. For example, the Coca-Cola bottle is a famous industrial design, and we've most recently had some very public lawsuits between Apple respecting the design of their iPhone. So they're only protecting the shape of it. So that's industrial designs. Trade secrets is the sort of alternative IP that people use as a way to protect their proprietary materials without disclosing it in any of the above registration processes. So oftentimes, you know, with trade secrets, people will protect them through confidentiality agreements, through processes at their place of manufacture, at their business, so that these secrets stay secrets, and that's how they're protected. The most famous ones are for recipes like Coca-Cola and Kentucky Fried Chicken. So we can move to the next slide. So those are the types of IP. Now, with respect to these agreements listed here that I'm going to talk about today, they can apply to any of those types of intellectual property. They can apply to all of your intellectual property as a group. It's important to define intellectual property in each of these types of agreements so it's clear what you're talking about, or it can be specific to a trademark, or it can be specific to a given process or a patent for a given product. So I'm going to talk about each of these agreements today. This is not all of the types of intellectual property agreements. I just think they're the most important ones, and ones that come oftentimes in the beginning. When you're starting out, you've got some proprietary materials, you've got a new technology you've developed, or a new process, or you've got a new brand, and you're either trying to commercialize it, or you're trying to protect it, or you're trying to partner up with someone. All of those types of things come into play here. So these are the types of agreements that I'm going to talk about today. So I'm not going to go through this list, but I'm going to go through each one. So we can go to the next slide. So the first one I'm going to talk about is confidentiality agreements. This is the important agreement at the beginning, when you really haven't made any contact with anyone respecting partnering up either on your business for investment purposes or development purposes. This is at the beginning, and confidentiality agreements are important, especially with respect to IP rights, because many IP rights, you can lose them, in particular patent rights, if you disclose them too soon before you register or apply to register those rights. So in the beginning, confidentiality agreements are important. There's lots of precedents out there. Not a lot of people come to law firms for them. And quite frankly, most of those precedents that are out there are decent. What I want to focus on here today when I'm talking about confidentiality agreements is whatever precedent you have, make sure there's certain key elements in it. We're going to talk about those, when you use it, and then when you need to up your contract game and move on to another one of the agreements that we're going to talk about. Because many of the agreements that go beyond a confidentiality agreement will often contain confidentiality provisions, because it's important. This is your proprietary materials, your technology, your marketing, and so you just, you want it to stay between you and the party that you're dealing with or communicating with. So, it's really important if you've got an unregistered intellectual property right. Let's say you've got an invention and you've got a prototype for this invention. It's a new product, but you want to look for a business partner, you want to look for financing, you want to have discussions just from a business perspective, just business discussions. And you want to talk about this prototype that you've developed. Before you disclose that prototype or any unregistered IP right, you really should have a confidentiality agreement signed, certainly prior to any discussions about commercializing it with someone else or licensing its use to somebody else. You should also do it prior to entering into any partnership or business discussions respecting those rights. And, the precedents are good. I find that people fill in the blanks for the parties, and then they sign it and everybody moves along. And sometimes you'll have these confidentiality agreements where the definition of confidential information is so broad that sometimes it doesn't even cover what you really want to keep a secret. So make sure that in the definition of confidential information is a basic description of what you really want to protect. So, you know, if your prototype is for a new paper press, then, you know, you'll want to say that in the definition of confidential information. It'll list a bunch of other things like, you know, any business information, sales information, client lists, any of that you talk to this proposed partner about. So most of that is covered in the decent confidentiality agreement, but make sure that your technology is described very generally in there, or your trademark, or whatever it is that you're trying to have a discussion about. So we can go to the next stage. Next slide, sorry. Thank you. So the next type of agreement is called a material transfer agreement. Most people refer to them as MTAs. I hate when people do that, but you know, MTAs. Another type of material transfer agreement is an evaluation agreement or a testing agreement. So basically what's happening here is you have proprietary material. You've got something that it's your IP. You want to have it tested by somebody else to see if it's got certain product properties or if it acts the way you want it to act. You may want to know how it acts with other components, with other machines, with other chemical compounds. You know, sometimes you want to see how it will work. You know, let's say your IP is quite developed and you want to see how it works with another person's IP. So for example, you know, I have a client who develops vaccines. So they often want their vaccines newly developed to see how they work with certain established vaccine platforms. In other words, how do you deliver the vaccine? That's another technology. So we will have material transfer agreements that exist between the folks who own the vaccine and the folks who own the vaccine platform to see how they work together. Now, you know, when you're doing that, you need more than a confidentiality agreement. If you're actually transferring or giving a sample of your IP, or you're disclosing what your IP is so that the other party can do something with it, you need more than a confidentiality agreement, because you need to protect your IP rights in whatever you're giving them. And so, you know, we'll talk about terms, but it's key that you know, before this transfer takes place, you're pretty clear with the other party as to who owns what. So we can go to the next slide. So these are the typical terms for an MTA. So, you know, you want to define the IP to be tested or evaluated. If both parties are giving IP to the exercise, then you want to be clear about what both parties' IP is. You want to be clear in the MTA about how this testing or evaluation is going to be conducted. So, you know, who's going to do it? Is it going to be a select group of employees at the testing facility? Is it going to be one particular department of the testing facility? You know, where is this going to happen? Like physically, what premises is this going to happen on? And how long are you going to let the other party have your IP for to do this? You know, there's got to be terms in there that are clear that this is an evaluation. This is a testing. This is not a license. So you have to be clear that they can't use your materials for commercial production. They can't reverse engineer, you know, the IP or the materials that you provide to them. You should be clear about how they report their results. So most importantly, that they report all results. So let's say you've asked them to do an evaluation for a particular purpose, and during their evaluation, they find out something unique or an improvement. It's important that that's reported back to you. So confidentiality is important. And, you know, the basic terms of a confidentiality agreement are also contained in a material transfer agreement. I've, you know, highlighted in red something that's really important with these material transfer agreements, evaluation agreements. Not only that you establish in the beginning who owns what IP, but who owns the IP in the results and any improvements discovered during this process. So just like reporting, you know, things will happen in these evaluations, or when you're putting two people's IP together, you know, that, you know, improvements in your own IP, improvements in their IP, or there's some sort of joint IP coming out of this. So you have to be clear in the material transfer agreement before any of this evaluating starts, who's going to own what in what circumstances. Okay, we can go to the next one. The next slide, thank you. So research agreements, I put this in here, you know, there's research agreements are a little more detailed than a material transfer agreement. Usually the research to be done is done over a longer period of time and, you know, is more open-ended in terms of the subject matter. But, you know, a lot of times when you have evaluations or testing done by another company or another business, most times that's governed by these material transfer agreements or evaluation agreements. If the research is more involved or broader in its scope, sometimes, you know, you will hire a university prof or a university department to do the research for you. Those can be quite different from material transfer agreements just because of the nature of universities. So universities have, you know, professors in particular and students have ownership rights that are outside the norm pursuant to university collective agreements. So you have to be careful about IP rights here, even more so than with an MTA. You know, it's really important that you recognize that, you know, you're a business, you know, the technology you may be having researched by the university is, you know, the key asset of your business. So, you know, you don't want a university professor disclosing in, you know, a university publication any information that you don't want to be public, or any information that might affect your ability to file for a patent. So, you know, there's these publication issues because universities and professors believe that, you know, that there should be a free disclosure of all educational information. Whereas oftentimes from your perspective, you know, you're looking to improve the product, find out more things about what the product can do, and, you know, you're looking at protecting your right and commercializing your right. So research agreements, you have to be really careful for those reasons. Okay, next slide. License agreements. So these are the most common types of IP agreements that people come to see us about. So a license agreement is just simply an agreement where you allow others to use your IP. You still own it. You're just allowing certain people under certain circumstances and in certain geographical areas to use or distribute your product or services under certain terms and conditions. So it's not an assignment of your ownership rights in your IP. It is the best way to commercialize your IP because, you know, someone else is doing all the work and earning a bunch of revenue that they're, you know, giving you some of back just by virtue of the fact that you've developed this wonderful product or service or brand. So we can go to the next slide. So these are sort of the standard terms of a license agreement. So the first thing, in legalese is called the grant of the license. So basically you have to determine whether or not, you're going to give the license to just one person, or are you going to give it to a group of people? Are you going to allow just one person to use it, distribute it, manufacture it besides you, or only them? So most license agreements are non-exclusive. Some of them make them exclusive by territory. So where can you use it? So if we're talking about the trademark startup zone, so startup zone is going to run its business and provide its services in Charlottetown, but it also wants a startup zone in Surrey and Tignish and Summerside. So it may allow other organizations or committees to use startup zone under certain terms and conditions. So the one in Summerside can only use it within Summerside geography. The other is, from Summerside West, and the Surrey group is from Charlottetown East. So, oftentimes, you can determine, or you can say, no, we only want one other licensee to be able to use this, so that licensee can have it island-wide other than the city of Charlottetown. So, territory is important, whether it's exclusive or non-exclusive is important. Whether or not it's sub-licensable. So Startup Zone in Charlottetown is the owner of the trademark. They're going to allow Donna McInnes to use the trademark and provide the services in PEI, but not the city of Charlottetown. The question is, can Donna McInnes then license others to do it in Summerside, Tignish, and Surrey? Or do those have to be licenses directly between Startup Zone and each of those others? So sometimes you can limit the license to a particular product or a particular process. So, that should be a term in the license agreement. The term, how long does the license exist? Is it renewable? So usually they're for an initial period of 2 to 5 years, and then can be renewable for 1, 2, or 5 years after that, is most of the ones that I deal with. So in order to allow others to use it, you can receive royalties, which is lovely. It can be a percentage of the licensee's revenues, either gross or net. It can be a lump sum payment right at the start for the full term. It can be periodic payments, an annual set license fee per year. It can be a combination of any of those things. There's also, it's really important to get the termination provisions in a license agreement correct, because those are the provisions that deal with the end of the license agreement, and sometimes the end comes before the expiry because, there's been a breach of the license or the license terms or non-payment of the fees. So as the licensor, as the IP owner, you want to make sure that your termination provisions provide that, who's ever using your trademark or your patented product or process or copyrightable program stops using it immediately as soon as the termination provisions kick in, and that they return inventory or destroy it according to your instructions. So those are the very, very basic terms of a license agreement. There's more, and there's more detail, but those are the basics. So those are the things you should think about if you're considering licensing out your IP. So we can go to the next slide. Employment agreements. So employment agreements are not IP agreements, but employment agreements should have provisions related to who owns the intellectual property that's developed by an employee when they're employed by that employer. So it's just important. It makes things clear. Some types of intellectual property, for example, copyright, the ownership in an employment relationship of IP is determined by the Copyright Act. It's not determined by the Patent Act. So there's a bunch of case law about ownership of patents that are developed in an employment context, and there's a bunch of sort of factors that are considered. But all of it can be determined, whether any type of IP, you know, it can all be governed by an employment agreement. So the employment agreement will govern regardless of what the Copyright Act or the Patent Act says, because both of those acts say that if it's governed by an agreement, that the agreement will prevail. So IP provisions are important in the normal course in employment agreements. They're really important if employees are developing IP as a part of their job. So, you know, if you've got employees in an R&D department, you know, if you've got employees that you brought in specifically to develop products, services, processes, technology, it's really important that you're clear in the employment agreement about who owns the IP rights. The other important thing is moral rights. And so copyright, we've talked about at the very beginning, and copyright protects artistic works, written works, and computer programs. So if you've got someone who is developing some written materials for you, or they're developing software, even if you have an employment agreement that is clear, and if they are developing it in accordance with their work only, and the Copyright Act says that you as the employer own it, even, and that's great in terms of the employer. So they own the copyright in that situation. However, if there's there's a type of rights that are associated with copyright. So copyright is the right to reproduce the work, to sell it, to publicize it. Moral rights are personal to the author of that copyrighted material. So the moral rights are they're twofold. The right to be associated with the work as its author or to remain anonymous. That's number one. Number two, the right to the integrity of the work. So, you know, there's not a huge amount of case law on what is meant by the integrity of the work, but you can't make changes, even as the copyright owner or a copyright licensee, you can't make changes to the originally protected work that offend the integrity of the work. So for example, there's one case that involves a sculptor who developed Canada geese sculptures for the Eaton Centre in downtown Toronto. The sculptures were hung at the Eaton Centre. At Christmas, someone in the marketing department of the Eaton Centre thought it would be a good idea to put some red bows around the geese. The artist came to see to do some Christmas shopping and saw his geese with the bows on them, told the Eaton Centre to take the bows off. The Eaton Centre said, no, we own the copyright, you transferred the copyright, and we paid you for it. We are now the owners of the copyright in those geese. He said, yes, but you've affected the integrity of my work. I may have assigned the copyright, but the moral rights stayed with me, and I did not waive them in favor of you, so take the bows off. Anyway, the sculptor was successful. And so it's important in employment agreements that the moral rights be determined, and whether or not you should have those moral rights waived in favor of the employer, or whether or not they stay with the employee. So we can move on to the next slide. Development agreements. So it does exactly what its title says. This is where someone else is retained by you to develop IP for you or together with them. So, you know, for example, you might have an assembly line of products that you produce, and your main revenue comes from French fries. So, you know, you may want to improve your manufacturing lines, so you hire someone to build you better equipment at a specific point in that processing line. So it's important, usually this is done by, you know, if you're the French fry manufacturer, you're hiring a mechanical engineering firm or a manufacturing company to do this for you. It's important, whether it's on that level or whether you've got someone in a startup business that wants, you know, a computer program developed specifically for their needs. You have to be clear in this development agreement what is being developed, what the sort of the statement of work is, and who's going to own what in the IP that's developed. And that gets into questions like, you know, who owns what materials or information that were brought to the process initially, so often defined as background intellectual property rights, and who's going to own the end product that's developed, and how is each party going to be able to use this in the future. So next slide. I don't even know how I'm doing on my time. So this is the last slide. So just very generally, intellectual property is an asset, like the other assets of your business. So you can transfer that asset to another. You can do that by way of assignment. You can transfer the ownership to someone else. If it's protected by copyright, make sure you deal with the associated moral rights. And you can also register security against an intellectual property registration. So oftentimes you will see, you know, if someone's receiving financing from a financial institution and they're taking security over the assets of the company, oftentimes we'll get asked to register that security interest against a registered trademark with the Trademarks Office or a registered patent with the Patent Office. So that's what I have. Happy to answer any questions. I think I saw a pop-up at one point. We have a chat, we have a question. So from Sarah Lewis, Donna, would this be the same agreement if you have beta testers for an online training program? Okay, I'm not sure which agreement. Probably the material transfer agreement, yes.
Yeah,
right?
it was the material transfer one, yeah.
Yeah, so yeah, you'll want to know, so these things can be really tailored to what you need. It may be super simple, Sarah, depending upon how much access they have to the proprietary information. So let's say that what they're accessing is really not proprietary to you or not the unique part of what you're doing, then you wouldn't need one. But if it's something that is being developed further, then yes.
Great, thank you.
You're welcome. So Tim wants to know, earlier you referenced exclusive and sole as different things. Can you elaborate? Yeah. Do you know what? I drive some of my lawyer partners crazy, because a lot of times in agreements, you'll see the phrase exclusive and sole right to. They're actually two different things in trademark law and in patent law. So exclusive means you and the owner can use it. Sole means only you, and only you as the licensee. In fact, the owner can no longer use it. So that's the difference. Like, people often assume that the owner can always use it. That's not always the case. Sometimes the owner will own it, but they don't use it at all. They give all of the rights out to the licensee. Pat, Sebastian, are confidentiality agreements and NDAs effectively the same thing? Yes, they are. It's just a different title. Confidentiality agreement or a non-disclosure agreement are the same. So did anybody have any questions where they want to talk and ask the question?
And yeah, feel free if anyone wants to turn their camera and mic on too and ask a question to Donna face to face.
Hey, Don, I don't have a question, but I just wanted to thank you for the session. It was very informative. Appreciate it.
Oh, you're most welcome. It's very dry, and there's dry slides, which my marketing department hates when I do these quick ones and try and pack all this information in. But yeah, you're most welcome. My pleasure.
Anyone else?
We don't have any more on the comments either.
All right, sweet. Well, if anyone does get a question after this, Donna, if you want, oh, Sarah Lucia said thank you in the chat there. If you want to let everyone know what a good way to contact you is, and then we kind of touched on this in the last session too. For anyone who wasn't in the last session, you can find it on our YouTube, or I can send you the link. We recorded this one too. But if anyone does have any more questions, where should they reach out to you? And then also, if they have a question that might be suited to like an actual appointment with a lawyer, where maybe they should be like sitting down, like at what point should someone be chatting with a lawyer about IP agreements? What would your recommendations be there?
Okay. So, you know, I think it's, you know, most times, most people don't come to us on the confidentiality side. You know, as I said, there's decent agreements out there as long as you keep in mind those few tips that I gave today. You know, I think it's important with a material transfer agreement, if this is your the main asset of your business, you should probably have it at least reviewed by a lawyer. You know, I think that's a license agreement you should have reviewed by a lawyer. An employment agreement, you know, I think it's important not to come to Donna McEwen, the IP lawyer, but to go to an employment lawyer and say, look, I've got some employees that are, you know, that I've got inventing things for me as part of their job duties. So that employment lawyer will deal with that sort of stuff for you. Yeah, and commercializing, you know, I always say an ounce of prevention's worth a pound of cure, but it sounds so self-serving, right? For me to say that, come see me and get your agreement reviewed or drafted. But a good agreement, you know, will last you a long time and can be used for numerous parties. So, you know, if it's beyond a confidentiality agreement, you should probably consult with a lawyer. So I am with McInnes Cooper. I am in the Charlottetown office of McInnes Cooper. So if you put Donna McEwen into our website, you'll get all of my particulars, but I can provide them as well to Rachel. My direct line here is, I have to read my direct line, isn't that sad? 629-8624, but we are on at 141 Kent Street. For anybody who's the same age as me, it's the old Sam the Record Man building. But you know, there's not a lot of people out here the same age. So yeah, happy to hear from you. You know, and happy to answer any questions. I don't charge people usually for the first half-hour discussion about, you know, the general stuff about this is where I'm at, what do I do? I'll usually give recommendations, and then if they retain us to do things, then that's when you start to be a client who gets invoices. But other than that, I'm happy to answer any questions about this material or the trademarks material we provided last week, free of charge. And then, like I said, unless the firm is retained, I don't charge for general questions. So feel free to reach out.
Donna, I did have one other question, if I may. It just came to mind. I'm thinking about the case where you have an employee who happens to do work at home, and maybe it's something that is somewhat unrelated to what they're doing at their day job, but there may be some crossover. And I'm just wondering if you could speak about the IP that employee might be creating when he's at home. Like, let's say a software developer is tinkering with, you know, interesting AI stuff, but he also happens to work in that same field at his place of work. And like, what should that person be doing to perhaps protect their own IP that they may be creating outside of the workplace? And where does that cross over? How does that all work?
Okay, so the important thing here is that that is a very common occurrence, and where all of your lawsuits have arisen over. So the fight between the employer and the employee is just that situation, right? So the employee says, look, I used my own resources. I was at home. I was off work hours. Yes, it relates to what I do every day, you know, at my place of work, but I was doing this on the side, and, you know, I developed this on my own resources. So those are all the factors that are taken into account, because what the Copyright Act says, if we're dealing with computer programs, is that in an employment situation, the employer owns all copyright that was developed by the employee during the course of their employment. So that's what everybody's trying to figure out on the software side. What is during the course of your employment? So if you normally work from home and you did this during normal business hours and you used the firm's computer resources provided to you, then I suspect it's owned by the employer, okay? If you have an agreement though in place, there's no question, because the employment agreement will deal with off hours. The employment agreement will deal with, you know, developments that are in the same area. It'll deal with anti-competition. So you will sort of tick all those boxes and cover yourself off as an employer if there's an employment agreement. As an employee, it also allows you to be very clear about what's yours, what you're inventing on, you know, as your own IP versus what you do at your job. But yeah, look, there's a bunch of factors that are considered. So if there's no agreement in place and you're dealing either with software under the Copyright Act or an invention under the Patent Act, the Copyright Act is easier. Usually employer wins. If it's under the Patent Act, usually the employee does, because they'll be careful to be at home using their own resources, off time, not during work hours, and they can own it then. So there's just those factors to consider.
Interesting.
Does that help?
Yeah, it did. And it would be further complicated now that a lot of people are actually working from home, maybe using their own equipment to work on an employer's business. That must present some interesting challenges too.
So to me, that, you know, if you're working from home, you know, location shouldn't matter if you're working from home and it's clear under your firm's COVID-19 policy that you're working from home or you're working remotely. That would probably be, you know, more in favor of the employer. But I hear you. It's, you know, it's yet to be argued, and lawyers love to argue. So.
Right. All right. Thanks, Don. I appreciate it.
You're most welcome.
All right, sweet. So we have 10 minutes left, but are there any more questions for Donna before we wrap it up? All right, and Donna, if you have anything else you want to add, we'll just kind of wrap it up now. But thanks a lot for coming out for these past few sessions. They're definitely very insightful, and it's great that we have this content to be able to send out to folks in our community as well. So yeah, thanks a lot from the Startup Zone team. And anything else that you want to say to finish off? Yeah, thanks a lot, everyone, for coming.
No, just wanted to say thanks. Great group. It's always great to get questions and interact. So that's great. No, thank you for the opportunity.